General elections in St. Kitts and Nevis were held on the 5th of June 2020, um, and they were held in an environment that was unusual. Of course, we're all aware that uh, the entire world has been impacted by COVID-19 pandemic, and we here in St. Kitts and Nevis did not in any way escape the impact of it. We recall that late in March, we had a state of emergency that was introduced, and based on the state of emergency, a number of emergency power regulations have been instituted in order to manage our behaviors as a country. What it did do, or what they did do, was to affect the manner in which the elections were conducted. Because one of the key restrictions that was placed on the populace was curfews in the evenings. While we had lockdowns and we eased those lockdowns and restrictions, the health authorities advised that we should practice social distancing, wearing of masks, non-pharmaceutical type of protocols. And so there was put in place a curfew in the evenings that more or less eliminated the ability for political parties to hold the traditional mass gatherings and campaign rallies and public meetings. We saw, as a result, very innovative virtual campaigns, especially by the Team Unity administration. But the Labour Party themselves, they also had a very innovative Labour Day march in place on the internet, and had their own virtual campaign as well. There was therefore not the usual mass movements of people that we had. And when the election day came and went, we had some pre-election court challenges by the Labour Party, one of which was to challenge whether the state of emergency was really necessary, and they challenged the regulations to suggest that the Labour opposition party had an unfair advantage because the state operatives gave precedence to the governing party and so forth. They claimed, for instance, that access to state media, ZSZ, had not been put in place. There was a challenge in relation to voter registration, the voters list in Constitution Assembly 4, and the long running battle in relation to the boundaries case was also came up before the court in the days before the election. and they were all resolved in a rather direct and quick manner. And we went into the election on the 5th. The elections turned out to be a resounding victory for the Team Unity movement, where in St. Kitts they increased the number of seats that they had from 5 seats to 6 seats. And in Nevis they increased those seats there as well from 2 seats to 3 seats. Having, as it was, a majority in the parliament, in the new parliament, of 9 seats on the government benches, and there would be 2 seats on the opposition benches. And following that, there would have been a flurry of court challenges to the outcome of the elections. Election petitions were filed by the 25th of June. I should point out that the laws governing elections, the rules require that election petitions must be filed within 21 days after the return of the elections. So while returns were done on the 6th, the day after, to the Governor General, establishing who had been declared winners, you would have had 21 days after that to be able to file any election petition for it to be valid. So on the 25th of June, Ian Patches-Liebert, the Team Unity candidate running on the PAM ticket in Constitution number 1, East Bastia, filed the first election petition. In his case, he had lost the election by 24 votes, but there were some 99 rejected ballots in that constituency. And he felt that the majority of those rejected ballots, a significant number of the rejected ballots were valid ballots, or good ballots, and that he had had the majority of them. So he has petitioned the court to review those ballots to see if he can get enough of the rejected ballots to have him overturn the 24 votes that he lost to Jeffrey Hanley. Jeffrey Hanley, his opponent, Dr. Jeffrey Hanley in Constitution number 1, who had been declared the winner and who ran the Labour Party ticket, in his response has filed what is termed a recriminatory response to his petition, challenging Patches-Liebert's victory, not his victory, but challenging Patches-Liebert, that he was the benefit of a number of irregularities that I'll speak to a little later. The following Patches-Liebert's filing of his petition, the losing Labour Party candidates in St. Kitts, some 6 of them, all filed election petitions on the 26th of June. They claimed that the winning Team Unity candidates had been the beneficiaries of bribery, cheating, and general irregularities in the conduct of the poll. They claimed that in the distribution of land by the Ministry of Sustainable Development, for instance, this had been done as a bribe to voters to vote for the Team Unity candidate, and spoke to general irregularities in terms of the production of the voters list that was used, that there were names on the voters list that should not have been there, and so forth. So this was the questions that were raised by the Labour Party candidates in some 6 constituencies. 2 weeks later, well, I should say that went to before the court within a short order. By the 14th of July, the matters were heard by His Lordship, Mr. Justice Trevor Ward, QC, and he gave directions to the parties for the matters to be settled. The key direction he gave, however, was as a result of applications filed by the winning candidates. So that on the 13th, Thursday the 13th of July, the day before his first hearing, the winning candidates all filed applications to strike out the petitions filed by the Labour candidates. And those applications were based on the issue of whether the petitions had been served in time. And they claimed that because the candidates had failed to do the proper service, that they were fatal, that they all had to fall. So that when Ward had his hearing on the 14th, the day after, the attorneys for the Labour candidates asked for time to respond. And he gave another 2 weeks for them to come back. What I've seen is that when they did return to court on the 31st of July, that they had not filed anything up to the 30th. But on Friday 31st, at about 10 to 9, 10 or so minutes approximately before the hearings were to be had, that there was a simple notice that was filed in the electronic portal of the court that they intended to withdraw the application, the election petitions. And so that when the court actually met on the 31st with Justice Ward, they were given directions to file the proper Form 10 for the withdrawal of the election petitions, and were given, as it was, some 1 week, 2 weeks, 1 week to do so. They would have to ensure, for instance, that Form 10 would be filled out, and it would be all the reasons why they were withdrawing the petition would be done. That Form 10 had to be gazetted in the official gazette of the country. There is a requirement as well that the notice of withdrawal would have to be published in at least one newspaper in the state. While the official gazette had been done yesterday, the 5th of August, there still needs to be done the publication in a newspaper. And so Justice Ward has adjourned today the hearing for another 2 weeks for this to be done. After which it would mean that these election petitions would have been terminated, would be finalized. What would still have to be done is that the the winning candidates, the team unity candidates, have all applied for the court to award them costs in this matter. The first respondents in all of the election petitions who were filed by the Labour Party candidates, that is the winning team unity candidate, were all the first respondent in each petition. And they would have been represented by the team led by Douglas Mendes, SC of Trinidad and Tobago, and Christopher Hamill-Smith, SC based in Barbados. With them, they had Michael Kumina and another junior based in Trinidad, and they would have been instructed by Taliba Byron, Haynes Senkins, who would be joined by Natasha Gray as well. The electoral officials who would have constituted the second and third respondents in 4 of the matters, along with the fifth, the second and third, along with the 4th respondents in all of the matters, except for for 2 matters, would have been the supervisor of elections, the returning officer, the registration officer. And then there were the 5th, 6th, and 7th respondents would have been the members of the Electoral Commission, who would have been petitioned in 2 of the matters. And these would have been represented, that is the supervisor, the returning officer, the registration officer, would have been represented by Eamon Courtney, Senior Counsel SC of Belize, along with Ileana Swift and Raj Kumar from his chambers. And when it came to the Electoral Commission, the chairman and Mr. Joseph Liebert, 2 members, would have been represented by Mr. Reginald Armour, SC of Trinidad, while Jason Hamilton opted to retain counsel of his own on his own behalf and engaged Michelle O'Brien and Keisha Spence to represent him. The basis of the record applications that were had to do with the question of the service of the petitions on the respondents. Because although you're required to file the petitions within 21 days, you're also expected to file security of costs for any expenses that may be incurred in the petitions themselves. And this had to be done within 3 days of the filing of the petitions. What in essence happened was that while in some cases there had been a form of security of costs filed on the 26th with the petitions, the respondents recorded that they were served on the 1st of July, the 2nd, and even the 3rd of July in 4 cases. And in 2 of them, they were not served at all. They did not get a receipt of any service of the petition. They had nothing to answer as such. So this was problematic. In addition, those who had been served were actually served not with the election petition filed first on the 26th of June, but it was what they called an amended election petition that had been filed on the 29th of June, as well as the security for costs. And this sort of contravened the rules, and it would seem that once the respondents had filed their notice to strike out the applications, the petitions, that the petitioners, the losing Labour candidates, sought it best to withdraw the election petitions. And so that is really where we are at this point. The judge ultimately would determine, as we move forward, what level of costs should be paid for these cases. There's numerous cases that have been done. And normally, if there is no agreement on this level of costs between the parties, the court will have to assess the costs that would have to be paid. That has brought to an end, or will bring to an end, I believe, a very interesting saga in this year of 2020, COVID-19 in 2020, and general elections here in St. Kitts and Nevis. Of great interest over the last week or two, in the midst of all of the excitement brought about by the election petitions, was the news that the Court of Appeal had handed down their judgment in an appeal brought by the former Supervisor of Elections, Wingrove George, last year. Mr. George had been charged in 2017 for misconduct in the way in which he handled the elections of 2015. And he had gone before the High Court, where he had been ordered to stand trial at the Magistrates Court initially in this misconduct charges. He had appealed, and so the Court of Appeal, that is, has now determined that he should stand trial. This has been a long-standing matter in which the country had been appalled by Mr. George, while as Supervisor of Elections, and making announcements to the country in relation to the results of the 2015 elections. Suddenly stopped doing that. He left the country in limbo with a lot of uncertainty, and was one in which could have made many people uneasy. The matter had been passed to the Director of Public Prosecutions, and he in turn had brought these charges. Mr. George now would have to wait for a date to be set for him to be tried on these charges.